All, Honourable Member? This is the respect of all?
Yes, Mr. Speaker, all.
The question is that the aforementioned bills be debated as a cognate debate. All those honourable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Thank you, Mr. Speaker, and I want to begin by thanking the Honourable Member for St. Michael West and Leader of the Opposition for not trying to put any obstacles in the way of this debate this evening, because it is something that has happened, Mr. Speaker, in fairly short order, and it is because, as explained to me and interpreted by the ministry, we are under a serious timeline where we have to give some information to the OECD by next week. And in fact, Mr. Speaker, if I may make a general comment, I would say that this ministry seems to be always beset with having to meet timelines and deadlines, although in this particular case, we really ought not to have been in this position now, as I will refer to a bit later on in my presentation. Mr. Speaker, just to put what is here before us this evening in context, we are here because largely of the need to meet a certain standard set by the Global Forum, which really is a body or arm of the OECD comprising some 157 member jurisdictions. And the main role of the Global Forum is to ensure that all jurisdictions adhere to the same standard of international cooperation in relation to tax matters. So what the Global Forum did, Mr. Speaker, was to set a standard in relation to transparency and the exchange of information, which, after some revision, determined that in relation to transparency, there's a requirement that beneficial ownership information, or simply put, information as to who are the company's real shareholders, must be available for all legal persons and legal arrangements in all of the member states of the OECD. It also decided in relation to the exchange of information, a country is only considered to be meeting that standard when, and I will sort of quote here, but it's a bit technical, when reliable information foreseeably relevant to the tax requirements of a requesting jurisdiction is available or can be made available in a timely manner, and there are legal mechanisms that enable the information to be obtained and exchanged. So, Mr. Speaker, to put that in just very simple language, countries are sometimes concerned that their citizens or residents are not fully reporting to their country of citizenship or residence all of their investments or earnings abroad, as a result of which that country of which there are citizens or residents lose tax revenue because those citizens or residents are not paying their fair share of taxes. So that's to put it in very simple language. So in those circumstances, Mr. Speaker, where that jurisdiction has reasonable grounds to believe that that citizen is a shareholder in a company in that other jurisdiction, say X Limited, that country can make a request to the country where X Limited is incorporated or registered for information as to who are the beneficial owners or the shareholders of that company in X Limited, as I say. And they should get that information, once this is a reasonable request, in a timely manner. And that information should not be supplied as a result of any discretion on the part of anyone. That information should be supplied because there is a legal requirement that the information is to be supplied. And sometimes, Mr. Speaker, it can be a very complicated thing, where you have X Limited in Barbados, a company, of course, being owned by Y Limited in the Cayman Islands, which is owned by Z Limited in Canada, which is ultimately owned by the dubious resident of Canada. And beneficial ownership or ultimate beneficial ownership always reverts back to an individual. A company is always ultimately owned by an individual. Cannot ever, anytime it is owned by a company, you have to look further to see who owns that company until you get to flesh and bones as to who is the ultimate beneficial owner of the company. And it can affect territories in a real way, because in that scenario that I just outlined, where X Limited is in Barbados, owned by the shareholder ultimately in Canada, you can have a situation where the company in Barbados owns assets that it sells, and it makes money on the sale of those assets. It makes a capital gain. Now, in Barbados, capital gains are not taxed, but they are taxed in Canada. So unless the Canadian authorities, the competent authorities in Canada, usually the revenue authority in Canada, unless they are able to get to the bottom of the ownership of X Limited here to see that Mr. So-and-so in Canada owns that company, and in fact it made a capital gain, then they would never be able to get the tax that that individual should be paying in Canada. So, Mr. Speaker, that is a little nutshell and a simplistic way of explaining the standard that the Global Forum set in relation to transparency. Now, it is not enough, however, Mr. Speaker, to just put laws in place. And more you're finding that institutions are indicating it is easy to put a legal requirement in place. However, what they want to see you do is you should be able to have regular and comprehensive system in place of supervision and oversight to monitor the extent to which those who are obligated by law to carry out that law, how in fact they are implementing it and conforming to it. Don't just put the law in place and leave it there, but what do you have in place to monitor compliance of the legal obligations as stipulated? And in our case, what you're monitoring and ensuring is that the arrangements and the entities that exist are in fact compliant with the obligation to maintain information as to who are the legal or beneficial owners of companies at their registered offices. That is what you're seeking to ensure, because the law stipulates that that must be done. We have those laws in most cases, but you want to ensure now that there's some monitoring system in place that you check and verify that that is really happening. So there's a heavy focus, Mr. Speaker, placed on the availability of reliable information in relation to beneficial ownership of companies. And this emphasis is placed in the context of attempts by individuals to dodge their tax liabilities, and even, Mr. Speaker, in the context of money laundering as well. In both cases, people can seek to hide their true identity, sometimes, as you know, Mr. Speaker, by use of very complex corporate structuring. They'd hide their true identities. So you have to be in a position to unravel that complexity and get to the bottom of who is really the owner of these particular companies. That is the essence, Mr. Speaker, of the transparency requirement of the Global Forum standard. Now, Mr. Speaker, I said earlier that we should really not be in this position of having to hustle here today, as we are doing. In 2015, under the last Democratic Labour Party administration, Barbados was assessed by the said Global Forum in relation to the development of its legislation and its regulatory framework and the way in which it was being monitored for effective compliance, and how it was compliant with the Global Forum standard. It was found initially to be partially compliant, which is not so good. It applied for a review, and 1 year later, in 2016, it was in fact upped to being rated as largely compliant. That was in 2016. But, Mr. Speaker, significantly, although it was found then that Barbados was largely compliant, it was also told to the last administration what had to be done before June of 2018, when another assessment would have been done. What exactly they had to do to maintain that largely compliant rating, or even better yet, to go up to largely compliant, or even go better, sorry, to being fully compliant. Either stay at largely compliant or become fully compliant. And they knew what they had to do. Mr. Speaker, unfortunately, we are now being assessed again by the OECD's Global Forum in relation to that standard for the period July 1, 2015 to June 30th, 2018. And some deficiencies have been identified. Because things that the last administration were supposed to do before June 30th, 2018, they failed to do. And we are here today to take action that they should have taken within the timeline that they had, but that they did not take. And as Mr. Speaker, in the context of the failure of that last Democratic Labour Party administration to do what it should have done, that you see a large portion of the legislative framework that is here today. So with respect to the state of our legislation, which is the first phase of the standard, you see that we have the Foundations Repeal Bill, the Limited Partnerships Amendment Bill, the Societies with Restricted Liability Amendment Bill, the Companies Amendment Bill, and the Corporate and Trust Service Providers Amendment Bill, all of which have to be amended or repealed, and which should have been amended or repealed already by the last Democratic Labour Party administration. Mr. Speaker, just to go through them quickly, in relation to the Foundations Act, currently in force, still as I speak to you, and until this evening ends, the problem is that while the Foundations Act stipulates that the Secretary of Domestic Foundations must maintain a register containing information on the Foundation's beneficiaries, the Secretary is not required to be present in Barbados or to be subject to Barbados' jurisdiction. And accordingly, information on foundations may not always be available. Now, we have decided, Mr. Speaker, that we are going to repeal the Foundations Act, and we will bring a new Foundations Act as soon as we can. Currently, there are no foundations regulations in place. Having passed the Act in 2013, foundation regulations were never put in place. So there are no foundations in Barbados. The Act, as I said, passed in 2013, is a disaster. And even the distinction in the legislation between international foundations and domestic foundations can bring you under the radar again of the OECD's form of harmful FHTP, form of harmful tax practices, in relation to this distinction, and calling to question things like ring fencing and preferential regimes and that sort of thing, that we can do without. So we have every reason to repeal that act, Mr. Speaker, which we have decided to do. And so it's being repealed today. In terms of the Companies Act, Companies Amendment, the amendments there in relation to the Companies Act, there's quite a bit there. But firstly, in relation to external companies that carry on undertakings in Barbados, they obviously have to be registered in Barbados to carry on activities in Barbados. But there's no requirement for them to file information identifying their legal owners. So we've decided to make it a requirement that external companies engage the services of a corporate and trust service provider. And we've amended both the Companies Act and the Corporate and Trust Service Providers Act to include external companies in the list of specified entities in the Corporate and Trust Service Providers Act. And why did we do that, Mr. Speaker? Because corporate and trust service providers are required to adhere to international standards, international best practices, including procedures and policies that will enable them to be able to identify and verify the identity of their clients, ownership, in other words, of the entities. But even if that is deemed to be not sufficiently specific, corporate and trust service providers are also anti-money laundering obligated and regulated entities, which are required under the Anti-Money Laundering and Financing of Terrorism Act to take all reasonable measures to establish and verify the true identity of a customer and to establish and maintain, I'm quoting the legislation, evidence of the identity of a person. So once an external company or any company is placed under a service provider, the services provider has to ensure that the beneficial ownership of the external company is known and is available, and indeed kept at the registered office of the entity that it has the supervisory powers in relation to. So that's why we decided to place external companies there. In terms of partnerships, it was also pointed out that Barbados needed to ensure that beneficial ownership information is available in respect of all partnerships. So we decided to amend the Limited Partnerships Act so that when a limited partnership has as a partner an external company, limited partnership must have, again, its corporate services provided by a service provider and be treated the same way that I just outlined in relation to external companies. The Corporate Trust and Trust Service Providers Act is also amended in the first schedule to include a limited partnership that has an external company as a partner. All of this, Mr. Speaker, should have been done by the last Democratic Labour Party administration, but was not done. Another deficiency, Mr. Speaker, highlighted that should have been cured by the last Democratic Labour Party administration before June 2018, but was not, is the absence, Mr. Speaker, of a requirement in our legislation for the maintenance of legal and beneficial ownership information, in other words, shareholder information, in Barbados after the dissolution of a company or a legal entity. Once an entity is now dissolved, that seems to be the end of the matter. Mr. Speaker, we have changed that, and among the amendments to the Companies Act that we have before us, I said that there are quite a few. We have now enacted that we now propose to enact that when a company is dissolved, whether pursuant to an application by the registrar or more directly by the court itself, or after the court approves the final accounts of the company, the court must direct such person as the court thinks fit to take custody of the documents and records of the company. And that person must keep these documents and records in Barbados for 6 years following the date of the company's dissolution and produce them where so required. So now when a company is dissolved, there's still an obligation to have someone who takes physical control of the records and documents of a company that they must keep in Barbados for 6 years after the date of dissolution of the company and produce those documents whenever they are asked or required to do so. And similar amendments can be found in the Societies with Restricted Liabilities Act in relation to the dissolution of a society. Now, Mr. Speaker, I did say at the outset or earlier that it's not enough to put legislation in place requiring that entities maintain information in relation to their ultimate ownership at their registered offices. Just as important, or even more important, is the need to effectively supervise, as I said, and monitor compliance with the law by those entities. Now, Mr. Speaker, the Corporate Affairs and Intellectual Property Office, CIPO as we know it, is home to some over 25,000 companies in Barbados. Meaning that those domestic companies all have to file annual returns with the corporate registry, and those annual returns must include a certification by a director that an up-to-date and accurate account or record of the basic and beneficial ownership information of the company, whether incorporated or registered in Barbados, is being maintained at the registered office of the company. So when you file your annual return, a director has to certify that you can go to the registered office of this company and you will find there an up-to-date and accurate record of who the owners of that company are. Now, Mr. Speaker, penalties exist in law for the late filing of annual returns. And the corporate registry has been imposing the fines now again. Also, a number of charities have been struck off recently, some 53, for failure to comply with this requirement, and I believe that notice of that will be seen in the newspapers tomorrow, on Friday this week. I think it's some 53 companies, charities that have been struck off for failing to comply. There are a few pending to be, in terms of non-profit companies, that will also be struck off very, very shortly. And other domestic companies that have been failing for years to file their annual returns will also find that very soon they are going to be struck off the registry, off the register in CAIPO. So that, Mr. Speaker, the process has started. But, Mr. Speaker, with the best will in the world, CAIPO cannot police, it cannot, or monitor the veracity of a declaration by a director that there is accurate and up-to-date information on the ownership of a company at the company's registered office. Not when they have to deal with over 25,000 companies. They simply cannot. They were not built for it. They are not a regulatory institution. CAIPO is a registry. And that, Mr. Speaker, is all that it is. So the responsibility for monitoring and policing that has got to be transferred from CAIPO. It has to be. It cannot realistically, that duty cannot realistically be discharged by CAIPO. So what we have decided, Mr. Speaker, is that all companies, the gross revenue of which, as shown in its most recent financial statements, wherever the gross revenue exceeds $1 million, that company will no longer be required to file an annual return with CAIPO and will instead fall to be supervised by a corporate and trust service provider, which will then have the duty of ensuring that there is accurate and up-to-date beneficial ownership information in relation to that company at its beneficial office. So that responsibility is now shifted from CAIPO for entities over $1 million in gross revenue to the responsibility of a corporate and trust services provider, whom they will be now, once this becomes law, the fund will be entitled, will be required to register and secure the corporate services of. The remaining companies whose gross revenue are under $1 million, they will continue filing annual returns as before, and but they will be monitored by a, probably will be called a compliance unit, staffed by additional members to be added to the International Business Unit under the Ministry of International Business. And this compliance unit, if it is eventually called that, will then be responsible for monitoring the position in relation to those companies that earn less than $1 million, and the unit will monitor that. In addition to also monitoring, which it wouldn't be required to know anyway, the compliance by the corporate and trust service providers and entities licensed by the International Business Unit. So that will be the new structure, Mr. Speaker, that will be put in place. And in fact, there are currently 7 people on contract with the Ministry of International Business, who, together with other persons from the ministry, have actually been trained in the conduct of on-site anti-money laundering inspections, and who have already carried out at least 10 inspections in relation to anti-money laundering, which of course includes having up-to-date and accurate beneficial ownership information. And of the compliance unit that will be put in place, obviously will be permanent. The employees will not be on contract. It will be a permanent unit, adequately staffed, permanently staffed, and it will be very, very involved in monitoring and inspection. So, but Mr. Speaker, it's important to understand that unlike enacting legislation, a unit carrying out inspections and involved in the process of monitoring to ensure effective compliance, that is a work in progress. It is something that will be done over time and obviously will fall to be assessed over time, unlike the legislation that we will do today that by the same time next week will be the law of the land. This business of monitoring compliance is a work in progress. So they will have a bit more latitude in understanding that. Now, Mr. Speaker, this issue of monitoring effective compliance is the perfect segue into the one piece I haven't mentioned yet, which is the company's economic substance bill. Because that bill, like these bills, require not only the enactment of legislation, but also the monitoring of compliance as well with the legislation once enacted. This economic substance bill that is before us, Mr. Speaker, is really not new, really. Last year, just about this time or a little later than now, it was among the pieces of legislation that I introduced into this chamber. And I did go through it at some length on that occasion. What really is before us today is a set of amendments to that piece of legislation. And in fact, I believe every jurisdiction that enacted economic substance legislation last year engaged in some measure of revision, amendment to that legislation since it was enacted. And if they didn't amend, I know of 3 jurisdictions that outright amended their legislation: Bermuda, Cayman Islands, and I think the Bahamas. There are 3 anyway, Mr. Speaker. And those who didn't amend their principal legislation amended their guidance notes and or other subsidiary pieces of legislation, because substance is a new concept. It's a new concept, and it is going to be evolving, and it is evolving, and I would not be surprised if in a year from now I am back here again with a further amendment or update to what I'm putting here today, because it is evolving. I did believe that the amendments that were requested in relation to it, that it could have been brought here by way of amendments, but as opposed to repeal and replace. But the experts said, and one of the experts in particular is held in very high esteem, I could never fly in his face to question it. So the decision was that rather than amend, they would repeal and replace. But, Mr. Speaker, as I said, if we want to just do a quick recap as to what economic substance is about in a nutshell, and why we are in that terrain, the simple truth is, Mr. Speaker, that last year, in November, Barbados converged its tax rates between the local domestic corporate rate and the international business rate, and we converged our tax rate downwards to the international business rate, where we had a scale of a range of between 5.5% at the top and 1% at the bottom. Once that was done, Barbados became classified, in fact, we self-declared, self-identified as a lower tax jurisdiction, as a result of which it was necessary to enact substance legislation. Why substance legislation, Mr. Speaker? Because once you have a lower tax, once you are a lower tax jurisdiction, there's a tendency for people to decide to use your jurisdiction for the raw, vulgar benefits that they can gain in terms of their taxes. So people will be tempted sometimes to just set up shelf companies and use you to evade paying taxes in their country of citizenship, and you benefit maybe by way of a few dollars, but you have no benefit of employment or anything of the sort, expenditure by the company. All it's doing is paying you a lower rate of tax, but eroding the tax base of the country in which it is in fact registered or incorporated. So it is those companies primarily that are concerned about losing or facing the erosion of their tax base, and they said, well, okay, if you are a lower tax jurisdiction, at the very least, you will have to ensure that you have substance legislation requiring companies to carry on real business in your country. So you're required now to have the legislation stipulates the relevant activities that you must engage in, that if you are engaged in rather, there are 9 activities, that you must have substance in the jurisdiction. You must carry out your core income generating activities in relation to those activities in the jurisdiction. And what the core income generating activities are all set out in the legislation. You must have what you call your minor management in the jurisdiction. So you must have your board meetings in the jurisdiction. You must always have a quorum. You must take real decisions, and you must have your minutes and so on kept in the jurisdiction. It must be real activity in the jurisdiction. Then you must fulfill the adequacy test, which is you must have an adequate number of employees, depending on the type of business that you're doing. You must have adequate physical plant, and you must be incurring adequate expenditure given what you're doing. So you must have a real presence in the country in which you're purporting to operate, once you are a low tax jurisdiction, which Barbados became in November last year. So that, Mr. Speaker, is a nutshell as to what the Act is about. Now, in terms, Mr. Speaker, of the real changes to the legislation, there are about 7 or so that I identified, which I will just mention. The first, there are some definitions in the legislation that perhaps weren't there last year, or they're spelled out in greater detail. For example, Barbados Competent Authority is now defined to be Barbados Revenue Authority. That was not stipulated last year. You have a fuller definition of resident company. You have a definition of financial services, which is a part of banking business. And a number of definitions have been expanded or included for the first time. So that's the first point I would make. Then there is also provision for a reduced economic substance reporting obligation in instances where a single-purpose equity holding company satisfies certain conditions and where a resident company is controlled by residents of Barbados as defined in the legislation. There's also provision that any company claiming tax residence outside of Barbados will nonetheless be classified as a resident company, meaning a resident of Barbados company, and therefore subject to the provisions of the Act if it fails to satisfy the director that it is in fact tax resident outside of Barbados. There's a provision also for spontaneous exchange of information between Barbados's competent authority versus Barbados Revenue Authority and the competent authority of another jurisdiction where there is non-compliance with the provisions of the Substance Act. So if a company is in breach of the Substance Act, doesn't fulfill its requirements, then automatically there will be a communication between the various competent authorities of Barbados and that country where the company is in fact initially registered. Where there's high-risk intellectual property, whether you comply or not, there is, again, a spontaneous exchange of information between Barbados and the country where, among other things, the ultimate beneficial owner of the company involved is. Or where a company resident in Barbados claims that it is in fact tax residents in another jurisdiction. If they're saying that we are not really resident here in Barbados, we're resident somewhere else to skirt around or circumvent our requirements here, then we'll also notify the country where it is claiming to be tax resident and alert them that this company is sort of fooling around here, but they're claiming to be tax resident over there. So please be advised and carry out your investigations and take whatever measures you deem that you should take. There's also a substitution of the penalty initially included of $150,000 for failure to provide information or for inaccurate information. The penalty currently in place is stated to be $150,000. That has been lowered, in fact, to $10,000 because of, that was really way out of whack with what other jurisdictions had in place. So we felt that we could bring it in line with reality. So it's come down from $150,000 to $10,000. Also, Mr. Speaker, and this is a fairly significant, an important amendment, a nice amendment, there's a provision allowing the director to inform a resident company that has failed to meet the economic test substance of what remediation steps must be taken in the event of a minor breach. So if you're not in a major breach, and a minor breach is actually considered to be where you don't have enough employees, you would not be penalized immediately. You'll be given a period of 12 years without, during which you will not be under any penal sanction to rectify it. But if you do not rectify it after the 12 months, then you would then fall to be penalized. They do have that within a space of 12 months to be notified of it and to remedy it if it is a minor breach. I don't believe that many or any other jurisdictions, if we're not told that didn't find any that had that provision, but we felt that we could include it in our provisions. And then, Mr. Speaker, significantly again, provision mandating the director, and this is the Director of International Business, to notify the registrar in the event of 2 consecutive failures of a resident company to meet the economic substance test, and the power of the registrar in those circumstances to exercise the discretion to strike that resident company from the register. Where you are, Mr. Speaker, guilty of 2 consecutive failures to meet the economic substance test. So those are the major issues that I think differences between what we have now and what we are moving to by virtue of this repeal and replacement of the economic substance test. Effective compliance, Mr. Speaker, as I mentioned earlier, this is a requirement not just to pass a Substance Act or amend it, but you also must ensure and demonstrate you have systems in place to effectively monitor compliance of the requirements of the Economic Substance Act. And what has already been done, it should be fully up and running certainly before the end of this year. The ministry has already engaged the services of a reputable company that is in the process of installing an IT platform in the International Business Unit, where, again, it would not be realistic to think that you could have all these declarations of substance that have to be filed by all of the companies manually. So there will be on that technology platform, IT platform, there will be the filing of documents and your declarations online. And if and when anything is triggered, red flags are raised, if any, then in fact you will be called to act and go on site to check out what might be amiss, to ensure that appropriate action is taken against the person in breach for non-compliance. So we will have that IT platform. We will also have the compliance unit that I spoke of earlier to be able to act in the event of any breach, and to ensure that you monitor what's going on in relation to entities that have to comply with this economic substance. Mr. Speaker, as I conclude in the minutes I was allocated by my colleagues, they told me I wasn't to go past 10 minutes. They're not sure. Mr. Speaker, to conclude, there are some, for purposes of completeness, there are some other non-specific amendments in the company's amendments bill before us today. Firstly, there's an amendment in relation to the Section 15A2. When this act, the Companies Act, was amended earlier this year in May 2019, this year in May. In fact, somehow what is currently in the proposed, what is to the proposed subsection 2, which always should have been subsection 2, somehow it got knocked out of position and ended up as subsection 5. So what we've done in this amendment is just to simply put it back in its correct position at subsection 2 of section 15A. So we have knocked it back into position. There's also, Mr. Speaker, the evidentiary requirement in relation to documents executed overseas. And there has been a lot of contention about this over the years. Some, and I am going to be very, very frank, Mr. Speaker, some attorneys, some, in my view, at times thoroughly incompetent or wicked, have sought to really be difficult, unnecessarily so, and to file documents executed overseas with no notarial or other seal in place to verify the signatory of the document, and sought to present it to CAIPO, and were demanding that CAIPO take it. Now, you see, there was no provision in the Companies Act before for it, that is to be correct. But, you know, there's a provision in the Evidence Act that this does state what qualifies as adequate verification of a document, particularly when executed overseas. Now, what we have done to remove all doubt is to place specifically in this amendment today the requirement that will obtain when documents are executed overseas and presented to the registry at section 14, in clause 14 in this amendment, where it says, notwithstanding subsections 2 and 3, the registrar may require any document required or sent to him pursuant to this act that is signed outside of Barbados to be verified on oath before A, a diplomatic or consular representative of Barbados, B, a judge of a superior court of record, C, a mayor of any city, D, a North Republic, or E, such other person as appears to the registrar to be empowered to administer such oaths. So for those attorneys now that feel that they have to be obnoxious, they no longer have to be, Mr. Speaker, because this amendment today puts beyond doubt what has to be done now for if a document executed overseas is to be accepted at the corporate registry going forward. Mr. Speaker, and the last point I will make is that in relation to the revival of a company that is struck off the record or the registry at Corporate Affairs and seeks to be revived or restored to the registry, all outstanding fees and penalties that were owing at the time that they were struck off. There's no objection to them coming back on. Be back on them coming back on, and they will pay any appropriate fees, fees at the time of filing to get back on. But in addition, there is now a requirement that to get back on, you not only pay the fees you have to pay to get back on, but all fees that were outstanding at the time you were struck off, or for whatever reason removed from the register, you have to pay those as well to get back on. So people will not abuse the system when they owe money, penalties and outstanding fees, just to come off the register and then go back on and continue as if nothing happens. So, Mr. Speaker, those in the 10 minutes I was allotted. Are the amendments that I have sought to bring to this chamber. As I said, they are pursuant largely to timelines that we have to meet, and I therefore, Mr. Speaker, commend them to this honorable chamber. And in relation to the foundation's repeal bill, I beg to move that that bill be read the second time.
The question is that the aforementioned bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that you do not lose the chair on this this House resolve itself in the committee for further consideration of this bill.
Make the second that.
The question is that the Speaker do not leave the chair and the House resolve itself in the committee for further consideration of this bill. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it.
This House is in committee.
Clause 1. Top.
Mr. Speaker, I beg to move that clause 1
Chairman.
stand part.
Mr. Chairman,
Chairman, I beg
you're
to
elevating me.
move clause 1 stand part.
Make the second that.
The question is that clause 1 stand part.
Thank you.
Honourable members in favor, please say aye. Those against, please say no. Think the ayes have it.
Clause 2.
Mr. Speaker, I beg to move that clause 2 stand part.
Make the second that.
The question is that clause 2 stand part. All honourable members in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Report.
Mr. Speaker, I beg to move that you do not report as on the Speaker the passage of one bill in committee.
Make the second that.
The question is that I do no report to His Honour the Speaker the passing of one bill in committee. All honourable members in favor, please say aye. Those against, please say no. I think the ayes have it.
Chairman's committee have reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
The question is that the aforementioned bill be read a third time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be set as the Foundations Repeal Act 2019.
Make the second that.
The question is the aforementioned bill be now passed and so cited. All those honorable members in favor, please say aye.
Aye.
Those against, please say no. We think the ayes have it. The bill is passed and so cited.
Order number 15, sir. In the name of the Honourable Minister of International Business and Industry, to move the second reading of the Companies Economic Substance Bill 2019.
That this bill be read a second time.
The question is that the aforementioned bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that you do leave the chair and that this House resolve itself in the committee for further consideration of this bill.
The question
Second
is that
that.
the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye.
Aye.
Those against, please say no. We think the ayes have it.
The House is in committee.
Clause 1.
Mr. Speaker, I beg to move that clause 1 stand part.
Mr. Chairman.
Chair.
Beg to second that.
One stand part. All honourable members.
Aye.
Those against, please say no.
Clause 2.
Mr. Speaker, I beg to move that clause. Mr. Chairman, I beg to move that clause 2 stand part.
The question is that clause 2 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 3.
Mr. Chairman, I beg to move that clause 3 stand part.
Beg to second that.
Which clause
The
again?
question is that clause
Oh, yes.
3 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 4.
Mr. Chairman, I beg to move that clause 4 stand part.
Beg to second that.
The question is that clause 4 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 5.
Mr. Chairman, I beg to move that clause 5 stand part.
Beg to second that.
The question is that clause 5 stand part. All honourable members in favour, please say aye.
Aye.
All those against, please say no. I think the ayes have it.
Clause 6.
Mr. Chairman, I beg to move that clause 6 stand part.
Beg to second that.
The question is that clause 6 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 7.
Mr. Chairman, I beg to move that clause 7 stand part.
Beg to second that.
The question is that clause 7 stand part. All honourable members in favour, please say aye. Members in favour, please say aye. Aye. Those against, please say no. I think the ayes have it.
Clause 8.
Mr. Chairman, I beg to move that clause 8 stand part.
Beg to second that.
The question is that clause 8 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 9.
Mr. Chairman, I beg to move that clause 9 stand part.
Beg to second that.
The question is that clause 9 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 10.
Mr. Chairman, I wish to propose an amendment to clause 10, subclause 1, paragraph D. I wish to have the number 2 in brackets on that line after the word subsection and before the word is changed to the number 5. So it would now read, of the date from which the penalty under subsection 5 is due, being not less than 28 days after the issue of the notice.
Beg to second that.
The question is that the clause as amended, do no stand part. All members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 11.
Mr. Chairman, I beg to move that clause 11 stand part.
The question is that clause 11 stand part. All honourable members in favour, please say aye. Aye. Those against, please say no. I think the ayes have it.
Clause 12.
Beg to second that.
The question is that clause 12 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 13.
Beg to second that.
The question is that clause 13 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 14.
Mr. Chairman, I beg to move that clause 14 stand part.
Beg to second that.
The question is that clause 14 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 15.
Mr. Chairman, I beg to move that clause 15 stand part.
Beg to second that.
The question is that clause 15 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 16.
Mr. Chairman, I beg to move that clause 16 stand part.
Beg to second that.
The question is that clause 16 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 17.
Mr. Chairman, I beg to move that clause 17 stand part.
Beg to second that.
The question is that clause 17 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 18.
Mr. Chairman, I beg to move that clause 18 stand part.
Beg to second that.
The question is that Clause 18 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 19.
Mr. Chairman, I beg to move that clause 19 stand part.
Beg to second that.
The question is that Clause 19 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Report passes.
Mr. Chairman, I beg to move that you do not report as on the Speaker the passage of one bill in committee with an amendment.
Beg to second that.
The question is that I do not report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, please say aye. With as amended, all honourable members in favour, please say aye. Those against, please say no. I think the ayes have it.
The chairman of committees has reported the passing of one bill with amendments.
Mr. Speaker, I beg to move that this bill be read a third time.
Beg to second that.
Question is that the aforementioned bill be read a third time. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be cited as the company's Economic Substance Act 2019.
Beg to second that.
The question is that the aforementioned bill be passed and so cited. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it. This bill is passed and so cited.
Order number 16, sir. In the name of the Honourable Minister of International Business and Industry, to move the second reading of the Company's Amendment Number 2, Bill 2019. Second reading.
Mr. Speaker, I beg to move that this bill be read a second time.
The question is that the aforementioned bill be read a second time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Again, do half and half.
Honourable member.
Yeah.
Again, hold. Mr. Speaker, I beg to move that you do not leave the chair and this House resolve itself into committee for further consideration of this bill.
Second.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
This House is in committee.
Clauses 1 to 9.
Mr. Chairman, I beg to move that clauses 1 to 9 stand part.
The question is 1 to 9 stand part. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it.
Clauses 10 to 15.
Mr. Chairman, I beg to move that clauses 10 to 15 stand part.
Beg to second that.
The question is that clauses 10 to 15 stand part. All members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Mr. Chairman, I beg to move that you do not report to His Honour the passage of one bill in committee.
Beg to second that.
The question is that I do not report to His Honour the passing of one bill in committee. All members in favour, please say aye.
Aye.
Those against, say no. I think
These are batteries. These are batteries.
The chairman of committees has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
Question is that the aforementioned bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be cited as the Company's Amendment Number 2 Act 2019.
Beg to second that.
The question is that the aforementioned bill be passed and so cited. All those honorable members in favor, please say aye.
Aye.
Those against, please say no. Me think the ayes have it. This bill is passed and so cited.
Order number 17, sir. In the name of the Honourable Minister of International Business and Industry, to move the second reading of the Corporate and Trust Service Providers Amendment Number 2, Bill 2019.
Mr. Speaker, I beg to move that this bill be read a second time.
Question is that the aforementioned bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that you do now leave the chair and that this House resolve itself in the committee for further consideration of this bill.
Question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it.
This House is in committee.
Clause 1.
Mr. Speaker, I beg to move that Clause 1 stand part.
The question is that Clause 1 stand part. All honourable members in favor, please say aye. Aye. Those against, please say no. I think the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
Beg to second that.
The question is that Clause 2 stand part. All honourable members in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 3.
Mr. Chairman, I beg to move that Clause 3 stand part.
Beg to second that.
The question is that Clause 3 stand part. All honourable members in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 4.
Mr. Chairman, I beg to move that Clause 4 stand part.
Beg to second that.
The question is that Clause 4 stand part. All honourable members in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Mr. Chairman, I beg to move that you do not report to His Honour the Speaker the passage of one bill in committee.
Beg to second that.
The question is, I do now report to His Honour the passing of one bill in committee. All honourable members in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
The chairman of committees has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
Beg to second that.
The question is that the aforementioned bill be read a third time. All those honorable members in favor, please say aye.
Aye.
Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited as the Corporate and Trust Service Providers Amendment Number 2 Bill Act, 2019.
Beg to second that.
The question is the aforementioned bill be now passed and so cited. All those honorable members in favor, please say aye.
Aye.
Those against, please say no. Me think the ayes have it. This bill is passed and so cited.
Order number 19, sir. In the name of the Honourable Minister of Industry and of International Business and Industry, to move the second reading of the Limited Partnerships Amendment Bill 2019.
Mr. Speaker, I beg to move that this bill be read a second time.
The question is that the aforementioned bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. Me think the ayes have it. Honorable member.
Mr. Speaker, I beg to move that you do not leave the chair and this House resolve itself in the committee for further consideration of this bill.
Second that.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye.
Aye.
Those against, please say no. Me think the ayes have it.
This House is in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
Beg to second that.
The question is that Clause 1 stand part. All honourable members in favor, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Clause 2.
Chairman, I beg to move that clause 2 stand part.
Beg to second that.
The question is that clause 2 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Report.
Mr. Chairman, I beg to move that you do not report to His Honour the Speaker the passage of one bill in committee.
Beg to second that.
The question is that one bill in committee. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
The chairman of committee has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
The question is that the aforementioned bill be read a third time. All those honourable members in favour, please say aye. Those against, please say no. And we think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be cited as the Limited Partnerships Amendment Act 2019.
Beg to second that.
The question is that the aforementioned bill be passed and so cited. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it. This bill is passed and so cited.
Order number 20, sir. In the name of the Honourable Minister of International Business and Industry, to move the second reading of the Societies with Restricted Liability Amendment Bill 2018.
Mr. Speaker, I beg to move that this bill be read a second time.
Beg to second that.
The question is that the aforementioned bill be read a second time. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. And we think the ayes have it.
Mr. Speaker, I beg to move that you do now leave the chair and that this House resolve itself in the committee for further consideration of this bill.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. And we think the ayes have it.
This House
Clauses 1 to 5.
Mr. Chairman, I beg to move that clauses 1 to 5 stand part.
I beg to second that.
The question is that clauses 1 to 5 stand part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Report.
Mr. Chairman, I beg to move that you do not report to His Honour the Speaker the passage of one bill in committee.
I beg to second that.
The question is, I do now report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
The chairman of committees has reported the passing of one bill in committee.
Mr. Speaker, I beg to move that this bill be read a third time.
I beg to second that.
The question is that this bill be read a third time. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. And we think the ayes have it.
Mr. Speaker, I beg to move that this bill do not pass and be cited as the Societies with Restricted Liability Amendment Act 2019.
I beg to second that.
The question is that the aforementioned bill be passed and so cited. All those honourable members in favour, please say aye. Those against, please say no. And we think the ayes have it. This bill is passed and so cited.
Order number 14, sir. In the name of the Honourable Leader of the House, to move that the House resolve itself into a standing finance committee to consider the grant of sums of money for the service of this island.
Mr. Speaker, I beg to move that Your Honour do now leave the chair and the House resolve itself into Standing Finance Committee to consider the grant of sums of money for the service of the island.
Beg to second that.
The question is that the Speaker do not leave the chair and the House resolve itself into a standing finance committee. All those honourable members in favour, please say aye.
Aye.
Those against, please say no. And we think the ayes have it.
The House is in standing finance committee.
In the name of the Honourable Minister of Home Affairs, to move the passing of a resolution to grant the sum of $1,100,000 from the Consolidated Fund and to place it at the disposal of the government to supplement the estimates 2019 to 2020 as shown in the supplementary estimates number 8, 2019 to 2020, which form the schedule to the resolution. Head 28, Ministry of Home Affairs, in the amount of $1,100,000.
Chairman, I do not plan to detain the House for too long a time on this supplementary. This $1.1 million is made up of $800,000 to the National Council of Substance Abuse and $300,000 to the Immigration Department. The last financial year, 2018-2019, the NCSA, as I will abbreviate it, would have received $2.1 million in the estimates. This year, the sum of $1.1 million was granted, and obviously, as the House is aware and the nation, Parliament agreed to conduct a midterm review halfway in the financial year to see how finances were going. All of this, of course, in terms of the economic restraint that this government found itself in on coming into office 18 months ago. But the NCSA, of course, is the main organization of government in Barbados, mandated to deal with illegal substance abuse, carries out an extremely important role in terms, especially in terms of its mandate connecting with the youth in terms of substance abuse. And, you know, its work within recent times is probably not as well known as it ought to be. I've certainly instructed the management and the board of directors of the council to do more public outreach in terms of communications and public relations to let the public know the good works it's doing, especially among the youth, in terms of schools, in terms of communities, in terms of partnerships with churches and NGOs, service organizations, Bardens. Quite a few MOUs have been signed recently, and but in a lot of cases the public doesn't know, and they will be embarking very shortly in terms of a more creative and extensive public relations program, because you have to get buy-in from the public as well to assist in this. So part of this supplementary, Mr. Chairman, is, as I said, $800,000 to keep NCSA as a going concern for the rest of the financial year. It would still be $200,000 short from what would have been granted in the estimates of the previous year. But the council will do with those resources, but also seek external funding to carry out its mandate better. But this is for, you know, operational costs to a large degree in terms of its programs as well, especially with the youth, in terms of buttressing and institutionally strengthening the council, which is necessary as well, sir, including upgrading of software to improve the functioning of the accounts department and other issues so related. In terms of the Immigration Department, sir, $300,000 for that, and this Parliament and knows, and through this Parliament we told the public of Barbados and wider Barbados, because immigration, sir, as we know, extends globally into the diaspora, etc., in our immigration policy and law. And the Immigration Department is one of the first two departments to go through reform in terms of digitalizing government, the government platforms are all connected in terms of ease of doing business and improvement of our competitiveness and our ability to facilitate just normal way of life, so not only for Barbadians, primary for Barbadians, of course, but also for our visitors. We all know, sir, we have spoken many times in debates in this Parliament over the last 18 months about the critical aspect of being able to do business in a speedier, more efficient manner. And the Immigration Department, and I thank, of course, the Honourable Prime Minister and my Cabinet colleagues, this Parliament, for agreeing for that department to be, as I said, one of the first of two to come into the new era of innovation and creativity that we are insisting of government departments and government platforms, sir. And this $300,000 is to assist further with that process, sir, because it means entering now all the paperwork on computer platforms, and obviously there's a cost for doing that, and that's part of what this is, sir, and also to continue to pay salaries, sir. Immigration Department did not lose any immigration officers in the retrenchment process that we were forced, and unfortunately, but unavoidably to do, and therefore the overall cohort of immigration officers remains the same, although our clerical officers were made redundant, sir. And clearly immigration is embarking on a comprehensive reform of the legislation and policy of the Immigration Department, to which Cabinet has agreed. So, and I would not go into detail because I look forward, as I'm sure this Parliament does, within at least early in the new year, to debating those reforms of immigration policy which the Cabinet has agreed on, and to help liberalize Barbados in terms of our population growth and our economic development, which is associated with population growth. And the Immigration Department, sir, the management and staff, I have to commend them for the reform process that is going on. I would have met, in fact, with the staff of the Immigration Department based at headquarters, less than about a half mile or a bit more from here, sir, yesterday afternoon, to personally tell them what Cabinet has agreed to, because they are the officers who, of course, will be responsible for implementing and working on a day-to-day basis in our new regime. And tomorrow morning, sir, first thing I'm going down at the airport to meet with other staff, the staff based at airport, and those who would not have been able to make yesterday as well, to inform them as well. And, you know, this is the kind of personal contact that we have been encouraged by our political leader, by the leader of this country to do. We cabinet ministers have been encouraged to do, sir. And this is part of the involvement of the people of Barbados and the government stakeholders in terms of what we are doing as a government, part of our transparency and accountability that we feel committed to abide by the people, unlike the last government, sir, where we as opposition MPs didn't even know what was going on, sir, in terms of the governance of the country. So, sir, I beg to move that Head 28 stand par.
Second.
Speakers?
Joe? Okay. So I beg to move that you do now report to His Honour the Speaker. Sorry.
Huh?
Right, I said
did already.
that. I said already.
It was seconded.
And
The
Minister
question,
Duguay
yeah,
second.
the question is that the head 28 do in the amount of $1,100,000 stamp part. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Mr. Chairman, I beg to move that you now report to His Honour the Speaker the passing of one money resolution in Standing Finance Committee.
The question is, I do not report His Honour the Speaker the passing of one money resolution in Finance Committee. All honourable members in favour, please say aye.
Aye.
Those against, please say no. I think the ayes have it.
Chairman of the Standing Finance Committee is reporting the pass of one money resolution in the Standing Finance Committee.
Mr. Speaker, I beg to move that the resolution be read a first time.
Questions that the aforementioned resolution be read here first time. All the honourable members in favour, please say aye.
Aye.
Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that the resolution be read a second time.
The question is that the resolution be read a second time. All those honourable members in favour, please say aye. Aye. Those against, please say no. Me think the ayes have it.
Mr. Speaker, I beg to move that the resolution be now agreed to.
Question is that the resolution be now agreed to. All those honourable members in favour, please say aye. All those against, please say no. Me think the ayes have it. This resolution is now passed.
Speaker, with that, we've come to the end of today's sitting. I beg to move the adjournment of the sitting until the 4th of December at 10 a.m.
The question is that this honourable chamber be adjourned until the 4th day of December,
3rd, Mr. Speaker, 3rd of December.
the 3rd day of December 2019 at 10 a.m. in the forenoon. All those honourable members in favour, please say aye. Aye. Those against, please say no. This honourable chamber stands adjourned until the 3rd day of December 2019 at 10 a.m. in the forenoon.